Thank you so much for having me here. My intervention today is about corporate complicity in the ongoing atrocities committed in Palestine. Yes? Center? Yeah? Great? Okay, great. So the ongoing atrocities committed in Palestine, including the genocide whose images reach our scenes daily, cheered on and materially enabled by states and corporations. Corporate complicity is not secondary to this violence. It is central to how it is sustained. From arms manufacturers supplying battle-tested weapons to banks and pension funds financing the occupation economy, to tech firms and private contractors providing surveillance and privatized aid delivery, corporations are deeply embedded in Israel's settler colonial project. Whether multinational or local, for-profit or ostensibly non-profit, these actors sustain the denial of Palestinian self-determination, underpin occupation and annexation, and are complicit in the gravest crimes under international law. Since 2023, this dynamic has only intensified. Yet let us be reminded that today's events are not sudden. It's not a sudden eruption, but the culmination of decades of settler colonial rule, a project predicated on the dispossession and erasure of the Palestinian people as a people. As Palestinian scholar Rafif Ziadeh has said, life under occupation never quite makes the same impact if we're only taught to react when bombs are falling. This slow death of siege, of systematic dispossession, of structural violence rarely registers. Indeed, decades of UN reports and human rights investigations have documented systemic violations. In its 2024 advisory opinion, the International Court of Justice cited racial segregation, apartheid, violations of the right to self-determination, and the unlawful acquisition of territory by force in declaring Israel's presence in the occupied territories, including its military apparatus and resource exploitation, unequivocally illegal. Since October 2023, these violations have only escalated. The International Court of Justice has ordered Israel to end life-destroying practices and reminded all states of their obligations not to transfer arms that could be used to commit international criminal violations. The International Criminal Court, meanwhile, has opened proceedings into war crimes and crimes against humanity. A large part of this endeavor and the unfolding genocide has been driven and enabled by the corporate sector, as we all know, and the reason for why we're here today. In this context, corporate engagement with Israel's occupation economy can no longer be seen as neutral commerce. It is directly connected to violations of Jus Cogens norms and to international crimes. Now, corporate complicity in atrocity is not new, nor are its laws that prohibit it. The post-Holocaust industrialists trials at Nuremberg established that corporate executives can bear international criminal responsibility when their enterprises enable or profit from mass violence. Today, international law makes it very clear commercial activities that facilitate the destruction of civilian life can trigger accountability at both domestic and international levels. A growing body of litigation reflects an increasing trend toward holding corporations to account. Corporate responsibility for violations of human rights, international humanitarian law, and crimes under international law more broadly is grounded in multiple instruments, some of which I'll detail now. So the first one is the Genocide Convention, which outright prohibits complicity outright and allows of the prosecution for persons, including corporate executives. The Rome Statute of the International Criminal Court provides that aiding and abetting, materially assisting crimes with knowledge of their consequences constitutes liability. While the International Criminal Court does not yet prosecute corporations as entities, managers and executives fall squarely within its jurisdiction. The UN Guiding Principles on Business and Human Rights require companies to conduct heightened due diligence in conflict zones and to disengage when their activities contribute to abuses. And the International Court of Justice has affirmed that once an actor knows of a serious risk of genocide, continued assistance can amount to complicity. Again, international law is very clear on this. It is also worth noting, and this is a common excuse, by the way, that complicity does not require intent to cause harm, okay? International criminal law is clear. It is enough that a corporation or its leaders knew or should have known that their assistance would foreseeably contribute to violations. Financing, supplying, or facilitating atrocity, even without desiring it, can make corporate actors complicit. However, in the context of Palestine, instead of disengaging as international standards demand, corporate actors that profited from the economy of occupation, as Francesca Albanese said, are now entangled with an economy of genocide in Gaza. So, in investigating corporate complicity during apartheid, the Truth and Reconciliation Commission of South Africa identified 3 levels of corporate involvement. The first order involvement was companies that actively designed and implemented apartheid policies. The second order were those that knowingly supplied goods and services used for repression. And the third order were businesses that benefited indirectly but still operated within and profited from a racially segregated system. This framework applies directly to Palestine today, where corporations are central to sustaining settler colonialism. Construction firms supply bulldozers to demolish homes and hospitals. Banks and pension funds underwrite the occupation economy. Tech companies provide spyware and biometric tools for surveillance. And privatized aid schemes, like the Gaza Humanitarian Foundation, have created militarized food distribution hubs described as death traps by international organizations. To illustrate particularly in the context of UBS, UBS promotes itself as a leader in sustainable finance, sponsoring the ongoing summit, which we're counter-summiting here today. At the same time, the UBS has substantially increased its investments in Elbit Systems, which we'll hear more about, Israel's largest private arms company. Public disclosures show that UBS expanded its shareholding in Elbit by more than 875% in the first quarter of 2024. That financial support has enabled Elbit to expand production and profit directly from war crimes and possible acts of genocide. Actually, clear acts of genocide, not possible. The legal test for complicity here, if we're going to apply the international legal framework, is quite clear. UBS cannot plausibly deny knowledge of Elbit's role, and the foreseeable consequences of its investment is the continued supply of weapons used to commit violations of international law. This is aiding and abetting in genocide. Let's be very clear with this. Now, I also kind of want to include some common corporate defenses or excuses used by UBS, but quite a few corporations in this, such as we create jobs, we comply with domestic law, we weren't directly involved in the atrocities committed, we are socially responsible, we're ESG compliant, etc., etc. These are all irrelevant in law, okay? Compliance with national law does not preclude liability, as the common excuse goes, and good deeds do not outweigh complicity in atrocity. I'm going to repeat that again. Good deeds does not outweigh complicity in atrocity. What matters is whether a company's conduct enables, exasperates, or facilitates violations. Like many big corporations, UBS's pattern of corporate profit from oppression is not new. During South Africa's apartheid era, Swiss banks, including UBS's predecessor institutions, were documented as central to sustaining the regime. In the 1960s, the chairman of UBS was asked whether apartheid was necessary, and he replied, not really necessary, but definitely desirable. So, how do we ensure accountability for corporations complicit in international law? It's very easy for me to really kind of give you the international legal framework and talk about, this amazing thing, but how do we ensure accountability? How do we enforce international law? And particularly corporations complicit in international crimes. The international community must ensure that corporate entities face legal consequences for their role in serious violations of international law. Companies must cease all business activities and terminate relationships that directly link them to or cause violations against them in line with their responsibilities under domestic and international laws, and of course the right to self-determination. But here lies the problem. The legal framework is robust, prohibition on genocide is absolute, and the law on complicity is very well established. Yet Gaza has revealed a collapse of enforcement. International law and the institutions designed to uphold it are being actively undermined, as we've seen in the news day after day after day after day. Okay? International law, the International Criminal Court, which has opened investigations into Palestine, faces sanctions and political attacks. The International Court of Justice has issued binding provisional measures ordering Israel to prevent genocidal acts. Yet states and corporations continue business as usual. Companies still profit from atrocity. Gaza is therefore not only a genocide, it is a test case for the future of international law. It forces us to ask, will law remain a universal limit on power, or will it be hollowed out by impunity and profit? What we see today shows that even the most fundamental prohibitions against genocide, starvation, and collective punishment can be eroded by political shielding and corporate profiteering. If corporations can bankroll atrocity under the banner of sustainability, then the credibility of international law itself is in jeopardy. This moment requires more than words. When states refuse to enforce the law, and when corporations continue business as usual, civil society becomes the enforcer of last resort. Again, I'll repeat this again. Civil society becomes the enforcer of last resort. Boycott and divestment are not just political tactics. They are bottom-up enforcement mechanisms filling the accountability vacuum left by governments and institutions. And this is not unprecedented, by the way. The end of apartheid in South Africa was accelerated by a sustained boycott, divestment, and sanctions. We stand in the same tradition today. What comes next really does depend on us, okay? If governments will not act, civil society must. Together we can help end these crimes as much as we can and restore meaning to the promise of never again. Thank you.